Colnaghi is a famous London art dealer and gallery, which also maintains a prominent gallery on the Upper East Side of Manhattan. A company called Jewellers Protection Services had designed and installed the security system at the gallery, but the system they implemented had one massive flaw. There was no alarm on the skylight overlooking the gallery. One day in February 1988, thieves made their way into the gallery by the skylight, and they stole 19 valuable paintings. Colnaghi sued for $10 million. Now, pretty clearly, there was no real dispute here about negligence. Nobody would argue that the company had not been negligent in the way that it designed the security system. However, liability for negligence was excluded under the contract between Jewellers Protection Service and Colnaghi. The only way the Jewellers Protection Service could remain liable to Colnaghi was if there was a triable issue of gross negligence, because in New York State, a company cannot protect itself from liability for gross negligence. Colnaghi, of course, argued that this was gross negligence, that it went well beyond normal negligence. They were probably right, but the Court of Appeals found that this is not the test at law. The court stated, used in this context, gross negligence differs in kind, not only degree, from claims of ordinary negligence. It is conduct that evinces a reckless disregard for the rights of others or smacks of intentional wrongdoing. In one sense, this is a very odd use of the term negligence because ordinary negligence is quite distinct from recklessness or intention. Gross negligence, however, reaches out to those concepts of recklessness and intention. It is a different type of negligence and not merely a different level of negligence. On these facts, the court accepted that while the conduct of Jewellers Protection Service might in fact have been very negligent, there was no evidence which could reasonably lead to the view that their negligence reached the legal standard of gross negligence. The court stated, the failure to wire a skylight, while perhaps suggestive of negligence or even gross negligence as used elsewhere, does not evince the recklessness necessary to abrogate Colnaghi's agreement to absolve jewellers from negligence claims. The story does have something of a happy ending. 14 of the paintings, including 2 priceless Fra Angelico paintings from the 15th century, were recovered in Manhattan 2 years later in June 1990.